Welcome to our module on the development and functioning of the U.S. legal system. I'm thrilled to have you all here as we embark on a journey that is essential for your academic and professional growth in the healthcare management field. This module is designed to provide a comprehensive understanding of how the United States legal system has evolved, how it operates today, and the crucial roles played by the three branches of government. By establishing this foundation, we will prepare you to delve into specific laws and principles, particularly those related to healthcare. We will begin by exploring the development of U.S. law, tracing its evolution from the Constitution and key amendments to significant Supreme Court cases. Understanding this historical context is vital for appreciating the current legal landscape. Next, we will examine the functioning of the legal system, including how laws are created, administered, and enforced, ensuring justice and order in society. A major focus will be on the three branches of government: legislative, executive, and judicial. We will discuss the distinct roles each branch plays in shaping and implementing laws, and how the system of checks and balances maintains a balanced governance structure. Building on this, we will transition to healthcare law, highlighting why a solid understanding of the general legal system is essential before tackling specific healthcare regulations. This knowledge is crucial for navigating and influencing healthcare policy effectively. Ethics are paramount in government. We will introduce the concept of political malpractice and explore various government ethics committees that ensure ethical conduct within the branches of government. Understanding these frameworks is key to fostering accountability and transparency. Understanding the legal system empowers you to engage thoughtfully with the laws that shape our society. I encourage you to participate actively, ask questions, and apply critical thinking throughout this module. Together, we will build a strong foundation that will support your future endeavors and enable you to make meaningful contributions to your professional practice. So, what is the law? Scholars often define the law as a system of principles and processes by which people in a society deal with disputes and problems, seeking to solve or settle them without resorting to force. Simply stated, laws are rules of conduct enforced by the government which imposes penalties when prescribed law are violated. This definition highlights the law's fundamental purpose: to maintain order, ensure justice, and protect the rights of individuals within a community. One, the most famous U.S. Supreme Court Justice Oliver Wendell Holmes once remarked that the law is a magic mirror wherein we see reflected not only our own lives, but also the lives of those who went before us. This profound statement underscores the dynamic nature of law. It is not merely a set of static rules, but a living framework that evolves with society's values, challenges, and aspirations. The law captures the essence of our collective experiences, mirroring both our triumphs and our struggles. Law serves multiple vital functions. It regulates behavior, protects individual rights, and ensures that justice is administered impartially. By establishing clear guidelines for what is permissible and what is not, law helps prevent chaos and conflict. Moreover, it provides mechanisms for resolving disputes peacefully, whether they arise between individuals, organizations, or even nations. In this way, law acts as a mediator, fostering a stable and predictable environment where people and organizations can thrive. So now let's talk about public and private law. Understanding these two branches is essential for comprehending how relationships are regulated and how justice is maintained within our communities. Public law governs the interactions between private individuals, organizations, and the government. It controls the actions between citizens and the state, overseeing the government's operation and structure. The primary aim of public law is to achieve society's valid public goals, ensuring that governmental power is exercised fairly and effectively. A crucial component of public law is criminal law, which prohibits behaviors deemed harmful to public order and prescribes punishments for those who violate these laws. By deterring misconduct and maintaining societal order, criminal law plays a vital role in protecting the community. In contrast, private law focuses on the recognition and enforcement of the rights and duties of private individuals. It encompasses areas such as tort and contract law. In a tort action, one party claims that another's wrongful conduct has caused harm, seeking compensation for the injury suffered. Contract law involves disputes where one party alleges that another has breached an agreement, seeking remedies like remuneration or the fulfillment of the contractual obligations. So now let's talk about the meaning of public policy. So, public policy is a fundamental legal principle that ensures no individual or entity can legally engage in actions harmful to the public or contrary to the common good. It serves as a safeguard for societal well-being by regulating behavior and promoting beneficial outcomes. The sources of public policy are diverse, including legislation passed by lawmakers, administrative rules, and regulations established by government agencies, and judicial decisions made by courts. Additionally, professional codes of ethics can reflect public policy by embedding societal values and standards within specific professions. Together, these sources shape and uphold the public interest, maintaining order and promoting the collective welfare. So, class, now we focus in this slide into the foundational sources of our legal system, which are essential for understanding how laws are created, interpreted, and applied. The primary sources of law include common law, derived from judicial decisions, statutory law, which emanates from federal and state legislatures, and administrative law prescribed by administrative agencies. Each of these sources plays a critical role in shaping the legal landscape. In instances where written laws are silent, vague, or contradictory, the judicial system steps in to resolve disputes, ensuring justice is maintained until legislative bodies can address and clarify the specific legal issues. This dynamic interplay between different sources of law ensures that our legal system remains robust and adaptable. So, in the following sections, we will explore each of these sources in detail, examining how they collectively form the bedrock of our legal framework. Understanding these elements is crucial for anyone aspiring to navigate or influence the legal domain effectively. So, what is common law? Common law refers to the body of principles that evolve from and expand upon judicial decisions that arise during the trial of court cases. Many of the legal principles and rules applied today by courts in the United States have their origins in English common law. Because a law could never cover every potential human event that might occur in society, the judicial system is doubly necessary. It not only serves as a mechanism for reviewing legal disputes that arise in the written law, but it is also an effective review mechanism for those issues in which the written law is silent, or in instances of mixture of issues involving both written law and common law decisions. It is very important to mention that legal cases are tried applying common law principles unless a statute governs. Although statutory law has affirmed many of the legal rules and principles initially established by the courts, new issues continue to arise, especially in private law disputes, which require decision-making according to common law principles. Common law actions are initiated mainly to recover monetary damages or possession of real or personal property. When a higher state court has enunciated a common law principle, the lower courts within the state where the decision was rendered must follow that principle. A decision in a case that sets forth a new legal principle establishes a precedent. Trial courts, or those on equal footing, are not bound by the decisions of other trial courts. Also, a principle established in one state does not set precedent for another state. Rather, the rulings in one jurisdiction can be used by the courts of other jurisdictions as guides to the legal analysis of a particular legal problem. So now this slide presents the explanations of some of the more important common law principles. Precedent. A precedent is a judicial decision that can be used as a standard in subsequent similar cases. A precedent is set when a court decision is rendered that serves as a rule for future guidance when deciding similar cases. Res judicata, which means the thing is decided, refers to that which has been previously acted on or decided by the courts. Stare decisis, the common law principle, stare decisis, meaning let the decision stand, provides that when a decision is rendered in a lawsuit involving a particular set of facts, another lawsuit involving an identical or substantially similar situation is to be resolved in the same manner as the first lawsuit. New lawsuits are thus resolved by applying rules and principles of preceding cases. In this manner, courts arrive at comparable rulings. Sometimes slight factual differences can provide a basis for recognizing distinctions between the precedent and the current case. Now, we see the second source of law in our legal system. Statutory law is written law emanating from a legislative body. Although a statute can abolish any rule of common law, it can do so only by express words. The principles and rules of statutory law are set in hierarchical order. Remember that the Constitution of the United States, adopted at the Constitutional Convention in Philadelphia in 1787, is first in the hierarchy of enacted law. Article 6 of the Constitution declares, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." They are very important words indeed. So, the clear understanding of these words is that the U.S. Constitution, federal law, and federal treaties take precedence over the constitutions and laws of the states and local jurisdictions. Statutory law may be amended, repealed, or expanded by action of the legislature, as was the case with the Bill of Rights, which details the first 10 amendments to the U.S. Constitution, which were ratified in 1791, and other amendments to the Constitution, such as the 14th Amendment, which provides that a state cannot act to deny equal protection of the laws to any person. The last source of law in our legal system is the administrative law. It is a comprehensive body of public law created by state and federal agencies to implement and manage enacted laws. It governs the administrative operations of government, as Congress and state legislatures delegate the execution and oversight of numerous laws to specialized agencies. This delegation is particularly crucial for healthcare organizations, which navigate a vast array of administrative rules affecting all aspects of their operations. There's an important act to get to know in this lecture. The Administrative Procedures Act outlines the procedures federal agencies must follow, defining their responsibilities and authority while providing legal remedies for those impacted by agency actions. Key regulatory powers of administrative agencies include licensing, rate setting by, for example, the Centers for Medicare and Medicaid Service, and overseeing business practices, for example, the National Labor Relations Board. When state and federal laws conflict, resolution can be sought in the appropriate federal court. The following case illustrates how federal and state laws may be in conflict. The plaintiff in Dorsten versus Lapeer County General Hospital brought an action against a hospital and certain physicians on the medical board, alleging wrongful denial of her application for medical staff privileges. The plaintiff asserted claims under the U.S. Code for sex discrimination violations of the Sherman Antitrust Act and the like. The plaintiff filed a motion to compel discovery of peer-reviewed reports to support her case. The U.S. District Court held that the plaintiff was entitled to discovery of peer-reviewed reports despite a Michigan state law purporting to establish an absolute privilege for peer-reviewed reports conducted by hospital review boards.